Good morning, afternoon, or evening. Your video is about to start. I wanted to remind you of our newer Wednesday, 1 p.m. live stream Q&A on all things Social Security. Visitors are welcome to post a question in the chat, and I'll do my best to answer it. It's on a first come, first serve basis, so please get there on time. Otherwise, if you care to be a member and get some different kinds of perks, feel free to click the join button below or just click it to learn about them. Anyway, I hope to see you Wednesday. If not, enjoy the video. Bye now. Good morning. So what do you do if you find that you have been working too much, didn't think you were, you'd been doing the math and thought that you weren't over SGA, and you either have a pending claim or you're already working, receiving disability benefits and are working a part-time and intentionally designed to be under SGA, and all that good stuff. But you find out, you get a letter from SSA saying, you have to give us some information here. Show us your pay stubs, so they can determine if you're over SGA and or if you're over TWP or have popped into the TWP period. That's trial work period. So SGA, as you might know, is substantial gainful activity. And it comes up in a lot of different aspects to a Social Security disability claim, as well as, thereafter. So it comes up a lot of different times. If you did the math and you were like, no, I could have sworn I was under SGA, I did the math, and you adjust it annually, of course. Make sure, because this can be, if you are just skimming over SGA, this could be something that will bring you under SGA. You have to get each pay stub so that you can look to see how many of the hours on that pay stub were sick time or vacation pay or something like that. Things that might be able to be subtracted, because the SGA is designed to show your activity, as represented by the numbers. And if some of the numbers are from non-activity, just getting paid for a sick day, paid time off, that wouldn't be reflective of your activity. So sick time, vacation time, at times bonus, but that gets a little trickier. But let's just go with the sick time, because most people have some of that in there periodically. And if it was a whole day of sick time, it could really knock you down by, if you were just flirting with SGA and went over, and then you realize, well, that was a sick day, you could pull that out and show them that it was sick pay. That's what the pay stubs can be used for. Very, very useful. It also drives home the point, guys, that when you flirt with SGA, when you design how you're going to work part-time, and which I think is the best thing ever for disabled people, collecting benefits or pending, either one, particularly after though, uh, flirting with SGA is dangerous because so many things can happen. You can get a raise. Some people are getting automatic raises. I just was working with a consult the other day who she just got like a $2.50 raise an hour. Didn't ask for it. It's just like standard protocol. And it goes across the board. No, I guess it's like a cost of living. I don't know. But fortunately, she knew to stay a few $100 below SGA. But a lot of people don't, everyone needs as much money as they can to get through these difficult times with inflation and all this stuff that, until certain things happen, that's going to take time to come down again, right? So it can be tricky. I wouldn't flirt with it. I don't dance with that line of SGA. Likewise, if your whole point is about staying under TWP, and everyone's got their different thresholds of, what they want to do, I wouldn't flirt with that either for the very same reason. Another reason is it is very common, particularly for lower paid work, but not necessarily, to be asked to put in an extra shift or to stay a little late. And it seems harmless to stay an extra half hour, hour and a half, maybe because the next shift person has to come on late. But that stuff adds up so fast. So being Mr. Nice Guy and doing that isn't necessarily going to be good for you. And being Mr. Nice Guy is not going to be an excuse when you go over SGA because you were able to work those extra hours and it put you over SGA. And as a reminder, when you go over SGA, depending on what stage they're looking at, one time over SGA can be the end of your disability benefits. It depends where you are in the post-win era. Otherwise, it can not mean that you're going to be ceased, but it can mean you owe the whole month back. Again, it's at different stages post-win that would be the difference in. There is obviously, if you're in your trial work period, you are not going to be losing any benefits for working over SGA that month, but something you got to look out for. Okay. Yeah, SGA is a big deal. We have a playlist on it, so feel free to look it up. But yeah, sick pay, look at the pay stubs, vacation pay, I would toss in that there as well because you are not working when you're sick and you are not working when you're getting paid vacation. So that's why it can be helpful for these purposes. It's not going to help you necessarily with everything else, but it'll help you with that. Okay, guys, SGA and sick days. Don't forget them. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Good morning. SGA. It's such a common question, and it is so very important for Social Security Disability or SSI. I'm going to try to just give you some overall really fast. You get a kind of a broad understanding of why this is important. In the sequential evaluation process, when the SSA decides if you are disabled and when, the first question they have to answer is the person working SGA now? Okay. At other times, they will look to see if you were doing SGA in the past, but it always has to do with if we are doing it during a period of alleged disability or it was a period of disability in the past. Okay, substantial gainful activity. That is what SGA stands for. I'm going to also read you a little bit from the Social Security narrative here so you can take a listen. And I will make sure that this there'll be a button at the end that has this exact page so you can click on it and read this for yourself because I know sometimes it's not so easy to absorb while you're just listening. So in this particular section, they are introducing the issue of work performed during a period of alleged inability to engage in substantial gainful activity, SGA, substantial gainful activity. Okay, it concerns work performed by a claimant filing for benefits or by an individual already entitled to benefits. That's what I alluded to before. And they go into two different things here. Substantial gainful activity means the performance of significant physical or mental activities in work for pay or profit, or in work of the type generally performed for pay or profit. So even if you're doing something voluntary and not getting paid, it can still be considered substantial gainful activity, regardless of the legality of the work. Thus, if you are doing something like dealing drugs and making money, that will still potentially count as SGA, even though dealing drugs might be illegal. Okay. Or if you're, I'm making stuff up here, prostituting yourself, is it SGA? I mean, you could think of all the different kind of illegal things that can be certainly substantial and gainful. Now they give you a definition or a narrative with regard to the term significant activities. Significant activities are useful in the accomplishment of a job or the operation of a business and have economic value. Work may be substantial even if it is performed on a part-time basis, or even if the individual does less, is paid less, or has less responsibility than in previous work. So merely dropping down in duties at work does not necessarily put you under SGA. Work activity is gainful if it is the kind of work usually done for pay, whether it's paid in cash or in kind. Now remember, in kind could be anything other than cash. It can be clothing, it could be perks, it can be food, it can be shelter, or for profit, whether or not a profit is realized. Activities involving self-care, household tasks, unpaid painting, I could talk, unpaid training, hobbies, therapy, school attendance, clubs, social programs, etc., are not considered to be SGA. Now, those things can be considered to determine whether someone is disabled or not, but they're not going to be used to determine if someone is doing work activity that if they were paid to do it, they would be earning over SGA or showing that they were doing SGA activity. Okay, so SGA, it's an activity review, as kind of described here. There's also a black and white amount of money that if we earn it and we don't have deductions from it, that would bring us to a lower amount. It can be also a kind of like a black and white finding of SGA without even looking at the activity. So SGA in 2023 was 1470. SGA in 2024 is now 1550. So if you hit those numbers, you would be deemed to be doing substantial gainful activity if that activity paid that amount. So that's kind of like the black and white. And again, if you hit the number, always look to some of the exceptions where certain amounts of that earnings can be deducted that could bring you below SGA if SGA is otherwise going to prevent you from filing or cause you a termination later. SGA, it's what we're doing, and it has to do with whether we are disabled or not under the rules. If we earn too much, we are not eligible for disability under the rules. And it's definitely an inquiry that takes a little more analysis, because sometimes brief periods of earning SGA or doing activity that would be deemed SGA can be argued to have been a failed work attempt. Okay, so it's not necessarily cut and dry. It is or it isn't. It really depends on a lot of questions. So if you're dealing with a question of SGA and you're concerned about it, you probably want to get a consultation on it or do a lot of reading, because it can make or break a current case or create a potential cessation of benefits later. Okay, SGA. By and large, when we first analyze a case as to whether or not we're going to take it, that's one of the questions I ask on my initial interview. Is what kind of work, when was it last done, how much? Because the question of SGA is going to go towards your application. There is a question, and I'll bring it up because on our format, we ask it when we gather our data. And it says, when do you believe your conditions became severe enough to keep you from working, even if you have never worked? And this answer would typically not be before you stopped earning more than SGA. It would usually be at the time you stopped earning SGA amounts or after. Now, that is not 100% all the time, but that's generally how it is. And the reason why they ask, when do you believe your condition might have? So let's say you're earning SGA, but you believe a year before you stopped working SGA, you went part-time, you stopped altogether, but a year before that, you feel like you were not able to keep working, although you still were. There is some remote instances where if we can prove that the work you were doing, and this would be by assistance from the employer confirming this by and large, if the work you were doing and getting paid above SGA for was actually not worth SGA and they were just kind of subsidizing you and being really nice, that could potentially come in there. By and large, though, that's a battle that unless you already have an employer willing to say you weren't working the amount they were paying you, they were kind of gifting you the other amount, this isn't going to bring you very far. So you could be spinning your wheels. So for us to consider it, the person has to have the goods in hand. Go get the letter from the employer saying how you were not earning your keep, but they were just kind of being nice to you. All right, SGA, substantial gainful activity. It's important when you apply. It is important all through your pending claim, very important for those that are working part-time, which is not necessarily a problem, but these are things that have to be addressed, and you need to talk about it with your representative and make sure you're not inadvertently putting yourself in danger. And it is also relevant after you stop, after your pending claim stops, you have prevailed, and now you are a beneficiary. If you are working part-time, this is uber critical, okay? You definitely want to have a fine analysis with it and make sure everything is working where it should and is not putting you in danger. Okay, SGA, substantial gainful activity. Talk to you later, guys.